Good evening. Welcome to the first of this year's Treasurer's Lectures. It's a particular pleasure to welcome as our lecturer this evening my friend and colleague at the Supreme Court, Master Andrew Burrows. Lord Burrows has the unique distinction of being the first person to be appointed directly to the Supreme Court from academia. After an immensely distinguished academic career, which included a chair at Oxford University, he decided to swap All Souls College for the old Middlesex Guildhall, where he's now a much valued colleague. In the time that he's been with us in the Supreme Court, his influence has been considerable. Those of you who are aficionados of the jurisprudence of the Supreme Court will have noticed that numbered side headings have started to appear in our judgments. Similarly, the number of references to the intention of Parliament has reduced significantly. You will now rarely see a side heading entitled discussion in any of our judgments, and I can promise you that you will never see in a judgment of the Supreme Court a theoretical point of law described as academic. There was, however, I must tell you, a shocking moment in court this afternoon in the Judicial Committee of the Privy Council, in Lord Burrows' presence, I'm sorry to say, when Lord Legate observed, but surely at that point is purely academic. There was a sharp intake of breath. It was a moment worthy of a Bateman cartoon. Joking apart, however, Lord Burrows has brought a fresh perspective to our work. He has a disconcerting habit of asking why we do things in particular ways, and this has prompted us to look at and to review our practices. His lecture this evening is entitled Insights from the Inside of the UK Supreme Court, and we greatly look forward to hearing it.
Well, thank you very much indeed for that kind introduction. And given my unusual route to the Supreme Court, it's perhaps not surprising that sometimes I find myself, while sitting in the Supreme Court, looking in as an academic observer, a fly on the wall, if you like, and thinking, what would I, as an academic, make of all this? And what I'd like to do this evening is to share with you some insights into the work of a Supreme Court judge that strike me as important and yet may not be fully appreciated from the outside. And I want to focus on 7 of these insights. And I should add that some of these insights are perhaps ones that can be gleaned from sitting in the Court of Appeal. But having never sat in the Court of Appeal, I can only comment on the Supreme Court. So insight number 1 is the huge importance of statutory interpretation. Before I started on the court, although I was very interested in statute law and had devoted my 2017 Hamlin lectures to the topic, I hadn't fully appreciated just how much of a Supreme Court justice's time is spent interpreting primary or secondary legislation. Since starting on the court in June 2020, I would estimate that over 2/3 of the cases that I have sat on have involved some issue of legislative interpretation. And no doubt that reflects the fact that, in the words of Professor Guido Calabresi, we are in the age of statutes, so that the common law is being swallowed up by statutes. In many of the cases I've been in the Supreme Court, the decision has turned almost entirely on statutory interpretation. That was the position, for example, in TW Logistics and Essex County Council, a wonderful case on the law on town and village greens, which involved interpreting provisions in the Enclosure Act 1857, the Commons Act 1876, and the Commons Act 2006. Similarly, in Costello and Dunkley, which concerned offers being made directly to trade union members rather than through collective bargaining, the decision turned entirely on the correct interpretation of section 145B and D of the Trade Union and Labour Relations Consolidation Act 1992. Most recently, we had the interesting question in News Corp and Ireland Limited against HMRC, handed down last Wednesday, as to whether the exemption from VAT for newspapers under the VAT Act 1994 included not only print newspapers, but also digital editions of newspapers. And in other cases I've been involved in the Supreme Court, statutory interpretation has been the backdrop to, or an additional point to, the application of the common law, as in Tinkler and HMRC, which concerned the common law, or perhaps we ought to include the equitable doctrine of estoppel by convention, but against the background of statutory provisions on the dealings between HMRC and a taxpayer. Now, in the light of that, you might assume that university law schools would spend a great deal of time on the study of statutes and statutory interpretation. But if you were to assume that, you would be wrong. In a survey carried out over 10 years ago for the Statute Law Society by my former colleague, Professor Stefan Vogenauer, and I don't think the position has changed, it was found that in fewer than 1 in 5 of UK law schools was there a dedicated course or teaching unit on legislation. And over half of those courses, where they did exist, were for first years. Clearly, what you do have are statutes or statutory provisions being looked at within a particular area of substantive law, contract, company law, employment law, and the like. But what you do not generally have are coherent examinations of statute law as a whole. And they tend to be treated at a basic introductory level in, for example, first year English legal system courses or legal skills courses. Even where statute law as a whole is taken more seriously, it's often either at a very theoretical level in jurisprudence courses or as a relatively small part of the constitutional law syllabus. It follows that if one was to ask most law students, possibly all, the basic question, what is the present English law and how one interprets a statute? I fear that they would be ill-equipped to answer. Nor do I think they would be conscious that last year there was an important restatement of the relevant principles of statutory interpretation by the Supreme Court in a case, I wasn't sitting on it, of Crown on the application of O against Secretary of State for the Home Department. The decision in that case was that it was within a minister's powers under Section 1(4) of the British Nationality Act 1981 to charge £1,012 for a child's right to be registered as a British citizen. And that was so despite many young applicants being unable to afford that fee. Lord Hodge, giving the leading judgment, said at paragraph 51, the appropriateness of imposing the fee on children who apply for British citizenship under Section 1(4) of the 1981 Act is a question of policy, which is for political determination. It is not a matter for judges, for whom the question is the much narrower one of whether Parliament has authorised the Secretary of State to set the impugned fee at the level at which it has been set. In other words, the role of the judges is to interpret what Parliament has laid down, and it is irrelevant whether the judges agree or disagree with the policy of the Act. And as regards the approach to statutory interpretation, Lord Hodge clarified that under the modern approach, statutory interpretation is concerned to identify the meaning of the words used by Parliament, and that in ascertaining that meaning, the context and purpose are important. Although he described them as playing a secondary role, which Lady Arden in her concurring judgment cast some doubt on, Lord Hodge accepted that explanatory notes, Law Commission reports, and government white papers may be helpful. He also confirmed that statements in Parliament reported in Hansard may exceptionally be relied on, provided the three conditions laid down in Pepper and Hart are satisfied. Those three conditions are: first, that the legislative provision must be ambiguous, obscure, or lead to absurdity. Secondly, that the relevant statement is of a minister or other promoter of the bill. And thirdly, that the statement made in Parliament is clear and unequivocal. On the facts, it was held that a ministerial statement could not be relied on in this case because the first condition in Pepper and Hart had not been satisfied, that is, the legislative provision was not ambiguous, unclear, or leading to absurdity. Sometimes students are taught there are three rules of statutory interpretation which the courts can choose between: the literal rule, the golden rule, the mischief rule. In my view, that is very misleading. There is only one correct modern approach, that one must ascertain the meaning of the words in the light of their context and the purpose of the provision, and none of those three rules quite captures that approach. I have to say that I've become ever more impressed by the work of those lawyers, the Parliamentary Council, who I first encountered in my days at the Law Commission. I think they do a wonderful job. They're often maligned because of the way in which their work is butchered almost by the time it goes through Parliament. And what one ultimately may get is not something perhaps that the Parliamentary Council had wished on us. I'm sure we've all got our favourites. My own favourite of something that doesn't seem to have quite gone right is Section 72 of the Housing Act 1981. 72(1) provides that rent tribunals are hereby abolished. 72(2), the functions previously conferred on rent tribunals shall be carried out by rent assessment committees. 72(3), a rent assessment committee shall henceforth be known as a rent tribunal. There's also this is secondary legislation, Lord Bingham's favourite, the Banking Act 1979 Appeals Procedure, England and Wales Regulations 1979. They provide any reference in these regulations to a regulation is a reference to a regulation contained in these regulations. As Lord Bingham says, no room for doubt there. The second insight is the large amount of time spent sitting in the Privy Council. I've been very surprised at the amount of time that Supreme Court justices spend sitting on Privy Council appeals. There are over 30 jurisdictions, primarily present or former countries of the British Commonwealth, which retain the Judicial Committee of the Privy Council as a final court of appeal. Although all Court of Appeal judges are also Privy Councillors, the Judicial Committee of the Privy Council, which normally sits as a panel of 5, is almost always comprised of at least 4 and usually 5 Supreme Court justices. Since I started on the Supreme Court, I have spent almost half my time on Privy Council appeals. In Trinity Term 2022, last summer, there were more appeals being heard in the Privy Council from one jurisdiction, Trinidad and Tobago, than there were to the Supreme Court in appeals from England and Wales. Now, some, albeit by no means all, of those cases are extremely interesting, not least from a private lawyer's perspective. They raise issues on commercial law and trusts on appeals from, for example, the British Virgin Islands or the Cayman Islands or the Isle of Man. There are also some very interesting constitutional cases involving interpretation of written constitutions, such as the fascinating Constitution of Trinidad and Tobago. It's also noteworthy that in some of those jurisdictions, Most obviously Mauritius, but we had one today, St. Lucia, where we're not even, although arguably in St. Lucia, not even, at least in Mauritius, dealing with a common law system. Mauritius is essentially a civil law system with a code based on French law. So we're deciding, as the apex Mauritian court, difficult questions on a very different system, even from the common law. So, for example, we had a case last year on water rights in Mauritius, where the system of property and analogous rights is very different from those in common law jurisdictions. Now, I've elsewhere stressed, when people have asked me, what are some of the differences between being an academic lawyer and a Supreme Court justice? And I've said, well, one big difference is you have to deal with every aspect of law, so that one has to be a generalist rather than an expert on a narrow area. But in the case of Privy Council sittings on appeals from civil law systems, that generalisation extends even beyond a common law system. The third insight is the relevance and difficulty of the law-fact distinction. In our work, the law-fact distinction arises in two distinct ways. The first is in relation to permission to appeal. All cases coming to the Supreme Court need permission to appeal, and this is almost always determined by the Supreme Court itself, sitting in panels of 3, with almost invariably the question being decided on the papers without a hearing. According to the Supreme Court rules, permission is only given on, quote, an arguable point of law of general public importance. And it's clear that in that respect, what counts as a point of law is very wide. There's no good reason to give a narrow meaning to what counts as a point of law, because the Supreme Court, in any event, has a wide-ranging discretion to decide what is an arguable point of law of general public importance, and hence whether permission to appeal should be given. Much more difficult is the second way in which the law-fact distinction arises, which is in relation to what may be termed the standard of review. That is, what test is the Supreme Court or the Privy Council applying in deciding whether it can reverse a lower court? Is it a correctness standard, or is it a different, less interventionist standard? Now, in relation to what one may term pure questions of law, a correctness standard applies. If the lower court's reasoning has taken the wrong view of the relevant law, that is, it has misinterpreted the rules laid down in the common law or legislation, for example, a point of statutory interpretation, it's plainly appropriate for the highest appellate court to reverse that and to apply its own view as to the correct law in question. Matters of law are for the higher courts to determine. In contrast, findings of fact are preeminently matters for the first instance judge, not least because the first instance judge will have seen all the relevant evidence and will have heard from relevant witnesses. In general terms, therefore, an appellate court will not interfere at all with the judge's findings of fact, but will defer to what the judge has found. However, it's well established by a line of authority which includes Edwards and Bairstow in the House of Lords and Henderson and Foxworth Investments in the Supreme Court, that even in relation to findings of fact, an appellate court can interfere where, for example, the finding of fact is perverse or irrational, or one which no reasonable judge could have reached, or where crucial evidence has not been taken into consideration. That's sometimes been referred to as where the judge was plainly wrong. But the most difficult area may be said to fall between questions of law and questions of fact. This is the area which can be referred to in various synonymous ways, such as the area of mixed law and fact, or requiring an evaluative judgment, or requiring the application of a legal standard. Examples are boundless, but they include the standard of reasonable care in the tort of negligence, what constitutes unreasonable interference with another's land in the tort of private nuisance, whether an invention is obvious so that it cannot be patented, whether consideration is inadequate in relation to the regime for the protection of creditors, whether a presumption of advancement has been rebutted, whether the threshold for taking a child into care has been crossed, which depends on the likelihood of serious harm to the child, whether a contractual exclusion clause is fair and reasonable, and under the Human Rights Act 1998, whether a measure taken is a proportionate interference with a convention right. Across all those questions, there is no simple answer to what standard of review should be applied, whether a correctness standard or one showing deference. It's helpful to think of a sliding scale, or as Lord Justice May has described it, a spectrum of appropriate respect from law at one end to facts at the other. Greater deference should be shown at the factual end of the scale and lesser deference at the law end of the scale. But in applying that scale, what often underpins the decision as to the standard of review is not so much an a priori distinction between law and fact, but rather whether in relation to the issue in question, there is any advantage in having seen and heard the relevant evidence, or whether the judge of a lower court, for example, may be said to have particular relevant expertise. And I can illustrate what I mean by a case in the Privy Council I was sitting in, Smith and the Attorney General for Trinidad and Tobago, where the question at issue was whether there had been an appearance of bias by a judge. Both the lower courts had held that there was no appearance of bias. In overturning that decision, we treated the appearance of bias as a question of law, or at least at the law end of the scale, so that a correctness standard was applied. And that was essentially because we considered ourselves to be in as good a position as the lower court to assess the evidence as to whether there had been an appearance of bias. We therefore substituted our view on the appearance of bias for that of the lower court. The fourth insight is the reliance on practical legal scholarship. I believe it's fair to say that my colleagues have great respect for the work of academic lawyers, and in particular rely to a significant degree on the work of academic lawyers who engage in what I've elsewhere described as practical legal scholarship, sometimes called doctrinal legal scholarship. And if you want an example of that, just look at the majority and minority judgments in the firm and Board of Trustees of the Tate Gallery decision handed down 2 weeks ago. Practical legal scholarship is legal scholarship that is focused on what judges decide and say and what statutes lay down. That is, the details of the content of the law and presenting a coherent bigger picture of that content. Perhaps because of my background, I certainly rely heavily on that sort of academic work, especially so that I can see the dispute in question in its wider context, and especially where the area of law is not one that I know much, if anything, about. What I would suggest in general is less helpful to the judges, albeit of course very interesting, is theoretical work as to, for example, the economic or moral underpinnings of the law. And following on from that, my fear is that in our law schools today, in particular in postgraduate legal study, too much weight is now being put on theory and not enough on practical legal scholarship. I'm in no sense wanting to devalue the merits of theoretical work, but I do fear that the pendulum in our law schools, especially in postgraduate work, is now in danger of swinging too far away from practical legal scholarship. As the Honourable Chief Justice Susan Kiefel of the High Court of Australia said in her 2020 article, today there are pressures on the academy which may have the effect of limiting the kind of research and writing which is useful to judges and professional lawyers. Funding may divert academic resources away from doctrinal law. It would be a great pity, she said, if judge-directed academic writing were substantially to decline. I say that not only from the point of view of judges, but also from that of the academy, and in particular young academics who may never experience what can be a kind of collaboration with the courts. It's my purpose here, she said, to encourage the continuance of that collaboration. Insight 5, the process by which most judgments are produced, is a collegiate one. Writing individual judgments used to be the predominant position in the House of Lords, although there were periods when that was the exception. The disadvantage of multiple judgments, although of course great fun for academics and law students to analyse, is that it's sometimes difficult to work out the ratio of a decision where there are, let us say, 5 judgments reaching the same decision for different reasons. And not surprisingly, such uncertainty in what has been laid down by the highest court does not appeal to practitioners. And the difficulties were brought home to me when hearing the case and writing the joint judgment with Lord Sales in TW Logistics and Essex County Council. That was the case on town and village greens that I mentioned earlier. Now, the peculiarity of the facts was that the registered village green in question comprised not a lush area of grass, but a 200 square metre area of concrete close to the water's edge in the working port of Mistley, Essex, across which port vehicles, including heavy goods vehicles, were often driven. And the question was whether the valid registration of that area of the port as a town and village green meant that the commercial activities of the landowner, that is the Port Authority, had to stop because of the criminal legislation protecting town and village greens. And in answering that question in the negative, it was of some importance for us to be clear as to the ratio of the leading Supreme Court decision in the area, which was Crown on the application of Lewis against Redcar and Cleveland Borough Council. But that was extremely difficult to work out because of the number of different judgments and views expressed, even though all the justices came to the same conclusion. In any event, it is time-consuming and off-putting for a reader to have to wade through several judgments instead of a single definitive judgment. On the Supreme Court, the present approach, therefore, is one of trying, if possible, to achieve a single judgment, whether written by one judge or increasingly common by 2 or more. I'm told by Professor Alan Patterson, who's the guru on these matters, that in 2021, the proportion of single judgments in the Supreme Court was 72%, which was the highest for 30 years. He told me last week that the figures for 2022 were 83%. Now, although dissenting judgments are permitted and are not discouraged insofar as a justice feels duty-bound to dissent, the overall trend towards single judgment means that if asked to write, one has a keen eye on gaining the agreement of colleagues. I've often been asked, since I started on the court, how is it decided who writes the judgment? And what's the actual process of judgment writing? Well, the process really starts with the post-hearing meeting that immediately follows the close of the oral hearing in a case. And in that meeting, each of the justices sitting is required to give orally, on a provisional basis, can of course change your mind, the decision one has reached, that is whether to allow or dismiss the appeal, with a summary of one's main reasons. And the others listen to that summary without intervening. And in line with the long-established practice, the order of giving those summaries, or as one might otherwise call them, mini-judgments, is in reverse order of seniority, so that the most recently appointed justice goes first and so on upwards to the presiding judge, who will be the most senior judge sitting. And I have to say at the start, I found that somewhat daunting, although of course, you have had the opportunity to read the papers and to think about the issues in advance. And then after that relatively formal part of the post-hearing meeting, there will quite often be a general discussion, although that may depend on whether or not there's a large measure of agreement between the justices. And it's towards the end of that meeting that the presiding judge chooses which justice, or it could be more than one justice, should write the first judgment, or one or more justices may, if the presider asks for volunteers, volunteer to write the first judgment. Now, that choice or decision to volunteer may depend on all sorts of factors, but will principally turn on the particular justice's workload, his or her expertise, his or her own degree of interest in the particular case, and the justice's views as to what the correct decision is in the case at hand and the reasons for that. And once the first judgment has been written and circulated by email, which usually takes several weeks, it will be commented on by email by the other judges sitting on the panel, who may choose to agree with it or to write their own concurring judgments, although, as I say, that's increasingly uncommon, or to disagree with it and to write a dissenting judgment. Occasionally, where there continues to be disagreement as to the outcome or reasons, there'll be a further meeting to reach a consensus or to clarify the precise disagreements. So as you can tell from this, the modern process does rely heavily on working closely with one's colleagues to try to achieve the best judgment possible. Insight number 6, the role of counsel in determining the scope of the decision. In deciding a case, the Supreme Court is to some extent limited by the issues raised by the parties. If a judge were to rely on a particular issue in deciding a case, and that issue had not been raised by the parties, and the parties had not been given the opportunity to make submissions on it, the decision would be regarded as procedurally irregular and unfair. And we had relatively recently a very striking variation of this situation, where on one of the central issues, counsel did not run what, at least at first sight, appeared to be a clear winning point. At the end of the hearing, the parties were asked by the court to make written submissions on that point. But the counsel who at first sight would stand to benefit chose not to do so. And counsel on the other side, therefore, had nothing to respond to. Although this was commented on in the judgment, it was felt to be inappropriate to decide the case on an issue that neither party had chosen to deal with. So we decided the case on the issues that had been raised. Now, that shows starkly that in a rare case, the Supreme Court is not deciding the case according to the correct law as it sees it, but is rather constrained by the submissions of counsel. Linked to that is that I've sometimes been asked since I started, not least by barristers who appear before us, as to what effect advocacy has in the determination of cases. Does it make any difference to the result whether we have good or bad advocacy? I find this a very difficult question to answer. Certainly, good advocacy is greatly welcomed because the good advocate can quickly and clearly cut through to the questions that are of real importance in the case and will have provided the materials that can assist the judges. One doesn't want to spend a long time trying to understand unclear and muddled submissions. But while recognizing that good advocacy improves efficiency, I am not entirely convinced that the good advocate is more likely to succeed in his or her submissions than the bad advocate. Although I accept that rather like the effect of advertising, it can be hard to know what it is that's influencing one's thinking. And then the final insight, the reasoning process by which Supreme Court justices decide cases. This, of course, is the million-dollar question which has been puzzled over and written about so much. And since joining the court, I've been pondering on it in the light of my own reasoning process and those of my colleagues. What dictates or guides our thought process when we formulate our decision and our summary of reasons in the post-hearing meeting, or more fully, when we write our judgments? In his famous Maccabean lecture, the great Lord Gough, one of my real heroes in the law, said the following: if I were asked what's the most potent influence upon a court in formulating a statement of legal principle, I would answer that in the generality of instances, it is the desired result in the particular case before the court. But when we talk about the desired result, we can do so at more than one level. At one level, he said, there is the gut reaction, often most influential. But there's a more sophisticated lawyerly level, which consists of the perception of the just solution in legal terms, satisfying both the gut and the intellect. Now, I would agree with that. I never disagree with anything that Lord Gough said, but I would want to express the position more fully in the following way. In deciding a dispute, and I'm going to confine myself here to a dispute on the common law rather than statutory interpretation, there are two requirements guiding or dictating judicial reasoning. The first is the requirement to reach a decision in the instant dispute that feels right. The second is the requirement to rationalize that decision by legal reasoning. Legal reasoning is dependent on the use of rules, principles, and policies to explain rationally the decision. The decision must be one that can be fitted into, or one might say must be shown to be coherent with, the bigger picture of the law by legal reasoning. And that legal reasoning typically involves, for example, careful attention to precedent, analogical reasoning, the consideration of hypothetical examples, and sometimes the policy implications of the decision, so far as judges are competent to take those into account. A major question with regard to that second requirement is how wide the coherence net should be cast. At the very least, one needs coherence with the immediate area of law with which one is concerned. So, for example, if one is dealing with sex abuse by a school teacher, and the question is whether the employer is vicariously liable for that sex abuse, one will at the very least wish to consider other decisions on vicarious liability dealing with sex abuse. The materials on that immediate area of law will have been supplied by counsel, and some judges may be content to seek coherence within those relatively narrow confines. Others will want to go on to consider cases on vicarious liability that have nothing to do with sex abuse, but assist in providing the bigger picture of the law on vicarious liability. Still wider, one may wish to consider how vicarious liability fits with, let us say, the liability of a principal for its agent. Famously, Ronald Dworkin thought that it was incumbent on judges to cast the net ever wider still by seeking to fit the particular decision into the whole of the common law and, so far as based on principle, constitutional and statutory provisions as well. He wrote, in Taking Right Seriously, "You will now see why I've called our judge Hercules. He must construct a scheme of abstract and concrete principles that provide a coherent justification for all common law precedents, and so far as these are to be justified in principle, constitutional and statutory provisions as well." Now, while I agree with Ronald Dworkin that Herbert Hart was incorrect to regard judicial reasoning in hard cases as turning on a discretionary choice analogous to that of a legislator once the existing rules run out, as Dworkin made clear, that is to misconceive what legal reasoning in hard cases involved. It's clear that Dworkin's description of the super judge Hercules goes well beyond the judicial reasoning process that occurs in practice. Judges certainly often cast the net wider than the immediate area of the law with which they're concerned, but the desire for coherence is limited and practically constrained, and I doubt whether any judge, even in the Supreme Court, is trying to produce the wide coherence postulated by Dworkin. It is, I think, important to stress that the two requirements that I've articulated are difficult to separate out in the judge's mind. They tend to coalesce at one and the same time. What feels right is not the intuitive feel of the non-lawyer, but what feels right to the judge who's been immersed in law and legal reasoning for decades. What feels right is inextricably bound up with fitting the decision within the bigger picture of the law. So, for example, we had a case in the Privy Council last year on whether a duty of care should be owed to a third-party beneficiary under a trust being operated by the customer of the bank who was the trustee. Now, a judge approaches the facts of that case with a feel for the difficulties involved in the claim, not least because the fact that the loss is pure economic loss immediately alerts the trained lawyer to a well-established need for restraint. The wider picture of the law cannot be cleanly separated from the decision that feels right. In general, the two go hand in glove. That isn't to deny that there can be cases where what feels right and the legal rationalization of the outcome clash, at least at first sight. Where there is such a clash, it's incumbent on a judge to try to produce a rationalization by legal reasoning that justifies what feels right. But where he or she cannot do so, correct legal reasoning is dictating a result contrary to what feels right, and in that relatively unusual situation, what feels right must be put to one side. One's judicial oath is to apply the law. So those then are my 7 insights from inside the Supreme Court. I hope that they may have given you some insight into the work of a Supreme Court justice, which I have found demanding and fascinating in equal measure. Thank you very much indeed for listening.